Transparency is often thought of as a shield. It's the thing where we name and shame and somebody feels bad about themselves. Transparency isn't a shield. Transparency is a sword. Our adversaries depend upon secrecy. They depend upon secrecy to steal our IP. They depend upon secrecy to traffic drugs, to traffic people. They depend upon secrecy to have slavery camps in Xinjiang. They depend on secrecy to have shadow fleets transporting Iranian and Russian oil to China. That secrecy can be attacked with transparency. And eventually, the people who are doing the law enforcement on the economic security tools will understand the importance of being able to see behind that veil.
Global companies face unprecedented risks and challenges in today's economy. To mitigate these legal and economic risks, companies are rapidly embracing and elevating the importance of robust ethics and compliance programs to promote positive corporate citizenship. On Corruption, Crime, and Compliance, you'll hear from industry leaders and insiders about how to create effective ethics and compliance programs that will mitigate risks and maximize financial performance. Here's your host, Michael Volkov.
Okay, welcome everybody. Michael Volkov here with Corruption, Crime, and Compliance. And I think we're really lucky to have two important voices in the anti-corruption fight, the global anti-corruption fight, I'll put it. First, returning for yet another appearance is one of our favorite guests, always a popular person, Scott Greytak from Transparency International US. He's the Director of Advocacy. And if there's anybody that knows what's going on in the political and legal world with regard to anti-corruption and work with the Congress, the administration, it is Scott. We welcome him here. And we brought along we're excited to have Josh Birenbaum, I hope I said that right, who's the Deputy Director at and tell me the FDD stands for again.
Foundation of Democracies.
Fantastic. Center on Economic and Financial Power, which focuses on illicit finance risks and global corruption. And previously, Josh was with Trace International, which we all know, producing articles, books, chapters, op-eds, model policies, everything. But we have two real experts here. First off, welcome. Thank you both for taking the time. I know this is going to be a popular episode because people are really struggling with a lot of the issues that you guys are right in the thick of. But thank you both, Scott and Josh, for joining us today.
Good to be with you, Michael. Unfortunately, there's plenty to talk about, so good to do it.
Nope, just pleasure to be here.
Well, let's start off with perhaps what we were blindsided, all of us, by, even myself, in terms of predicting what the new administration was going to be like with anti-corruption. And that was the 6-month pause on FCPA enforcement, which was announced shortly after the Attorney General was confirmed, Pam Bondi. And I point out, and you guys, we've discussed this before, that the first Trump administration was one of the most aggressive in terms of, they even had corporate monitors appointed from the DOJ standpoint from 2016 to 2020. And all of a sudden we got hit with this pause, which is at least 6 months on FCPA enforcement. Tell me, each of you, take a moment just to give me your reaction to that, what has resulted from that, and sort of what you see is happening.
Yeah, Michael, when I go abroad and folks from our chapters, we're in 115 chapters, we're headquartered in Berlin. When folks heard this news, they were shocked. Not only was the United States the first country in the world to adopt this policy, it pushed for it so hard at the OECD for the past 20, 30 years. We are the primary funder for the OECD, which has their working group on bribery to study this, to evaluate country compliance, to really be the tip of the spear. And all of a sudden, we've gone from the tip of the spear to the blunt end of the stick. It is extremely disappointing as a policy choice. I think it was interesting that even President Trump struggled to articulate a reason when signing the executive order that did this, because nobody wanted this. Companies are not calling for this. Obviously, civil society, folks who work in the government at the DOJ who know this, nobody was calling for this policy change. And so just like the complete 180 that the U.S. has done on this, I think what we should talk about a bit is what this actually means practically. I don't necessarily think that this will mean there is going to be more corruption from American companies being exported overseas. I think this is actually just going to be confusion and possibly a liability trap for any company that would dare take this executive order at its word and proceed with unethical behavior like this, because we all know the statute of limitations will outlast this administration. We all know that countries have their own laws. Other dozens of countries have similar laws where these companies can be ensnared in. It is not all it's been meant to be. But let me stop there and Josh, jump in.
Yeah, I think that's an excellent point. And I want to start with the point on this doesn't really change anything from a corporate compliance standpoint. The liability will still attach either from future administrations or, again, this administration has shown itself willing to move policy one direction and quickly another. So you just don't even know in the next 4 years if enforcement will come back. There's also overseas enforcement. But I'd like to also just give an optimistic read on where this may go. And it's similar to what we see in the security space, where perhaps the U.S. withdrawing a little bit allows other countries to stand up enforcement actions that they have never taken. For decades now, it's been the U.S. and the U.S. only standing out there enforcing bribery laws that every country in the world has on the books. Every now and then you'll get an enforcement action in the UK or somewhere else. But if like pulling back from Europe allows the European continent to stand up from a security perspective, maybe this pullback will allow some other countries to build up their resources for enforcement. And I see that as a positive.
Well, let me just say, you guys made great points, both of you, and we'll get into these a little bit more. But I will say from at least my perspective, in terms of working with clients and companies, global companies, everybody is we're not changing anything. We're staying the course. Of course, we do not pay bribes under any circumstances. And if anything, I'm seeing a little bit more internal communication that is done within companies to reinforce that point. What I do think we really have to watch is exactly what you two have talked about in terms of the other countries, other laws that are being enforced. These are global companies that have a reputation for ethical conduct and values that they want to maintain because it helps them to win business overseas. The companies that engaged in bribery, usually it's not a long-term successful strategy. We all know that. So I'm sort of saying stay the course, and particularly in this volatile time, we're not going to adjust our compliance program that we built over the last 20 years in response to FCPA enforcement. Now, I will say the point that you guys both made, which is really important, is, and Scott and Josh, both of you referred to this, is that our international role as a leader here in holding conferences, training prosecutors, doing everything that we used to do is gone. But we are seeing people starting to fill in the gap a little bit. I'm not saying it's going to fill it in all the way, but we're seeing more of an international interest. For example, we had the announcement from the SFO, from France, and from Switzerland on creating a task force for anti-corruption enforcement. And I think that was a response directly to the United States action. But if you guys could talk a little bit more about where you see the gaps and how those could get filled in. And then I want to get to some of the other issues that you already mentioned in terms of national security and other ways that this could sort of develop. But if you could sort of lead us into, is the State Department, for example, Scott, really standing down on the years and years of leadership? Is the Justice Department obviously is not playing a lead role right now? We've seen prosecutors reassigned from the FCPA unit. But go ahead and sort of give us your sort of global perspective on the impact this has had.
Yeah, I mean, globally, the short and strict is there is no substitute or adequate replacement for the United States role in enforcing foreign bribery laws. Like our friend Tom Firestone, one of the most knowledgeable FCPA attorneys out there, said at one point that the Southern District of New York has probably brought more foreign bribery in AML cases than all of the European continent combined. So the alliance and the open door that it had for other countries to join this new alliance is a great step. I'm encouraged that there has been some important enforcements in the UK, including their first enforcement against a foreign official for accepting and soliciting a bribe from a UK company, which is a great first piece of precedent there. But when the United States steps back, I mean, there is no way that the other OECD countries, even collectively at this point, can fill the gap. That's just the truth. So we have a lot of work to do in order to try and convince this administration to change course. I think the good news is it's only a pause. They are reviewing it. There have been no bills in Congress to build this into law, to go after the FCPA. Not a single member has filed a bill that would undermine the FCPA or delay it. Or, I mean, if anything, we've heard of a bill coming together that would increase the statute of limitations from 5 to 10 years as a way of signaling to stakeholders here that this is a temporary policy change and that there is still a beating heart of the anti-corruption constituency that's keeping eyes on this. Just to plug it, there is the Foreign Extortion Prevention Act. This is the new law that was signed a couple of years ago that gives the DOJ the authority to go after any foreign official that asks for or accepts a bribe from an American company, any company listed on a U.S. stock exchange or within the United States. This was never used by the Biden administration. They mostly ran out of time in being able to bring cases for it. We haven't heard that there's any reason that the Trump administration wouldn't use it. And frankly, it aligns so well with a lot of their other foreign policy interests of being able to protect American companies abroad to make them more competitive, especially against, Chinese or Russian state-owned companies that are all too willing and often eager to give bribes to a foreign official. This is a great tool for promoting American business. We just haven't seen it used yet. It's basically the United States and the UK that have a law like this. Ours is laying dormant. We do not want to see this go the path of the FCPA and basically be unused for its first decades, right? We think this is a really strong foreign policy and anti-corruption tool. And so we are encouraging the administration to try and make the most of it.
Yeah, I'd love to talk about the FCPA and FIPA, but let me start with the FCPA. I think that the FCPA is one of the great American laws, and it's made American businesses stronger and better in their ability to project a certain standard that makes them competitive in a global environment. And I think that companies recognize that, and we have to understand that American anti-corruption efforts are not just led by the administration, but are led by the private sector. So strong companies are still going to be pushing forward compliance programs that prioritize anti-bribery. And I think that the FCPA will be here for a long time, whether or not there's a pause or not. But I do just want to backtrack a second and talk about European enforcement, because frankly, European enforcement has been on pause for decades, right? When's the last time that France brought an action, that Spain brought an action? And so this idea that we need a forcing mechanism to require a more hands-on deck approach to foreign bribery, a more unified approach to foreign bribery enforcement, I think is absolutely correct. But I also think that smart companies are understanding that this is temporary, and they understand what value it gives for the reputation of U.S. and U.S. listed companies. And ultimately, for an administration that cares about the importance of the U.S. private sector and the strength it has abroad, I think eventually I wouldn't be surprised if this administration comes back around to the importance of the FCPA. The FIPA, the Foreign Extortion Prevention Act, is another fascinating bill that could see light of day under this administration. I think ultimately it will, but whether that is in the first 2 years or the second 2 years, lots to ponder on that. I'm not sure how quickly that's going to be prioritized with other interests.
You guys, I always say that you can figure out what DOJ is going to do by watching where the resources go. And if, for example, they moved, let's say, a whole bunch of prosecutors over to the National Security Division to do corporate sanctions enforcement, that's going to eventually happen because you put a prosecutor there, they're going to bring cases, and they had law enforcement lined up to help them. But we're also seeing sort of the transfer of people from the FCPA unit We've also seen, I think, the end of the kleptocracy initiative and some of the other asset sort of functions that DOJ used to do. And I think that there's no question, if I'm overseas and I worked with the U.S. as a prosecutor and I'm in France and I'm a prosecutor, the absence of the U.S. at the table is a big, big deal. Now, I do think you're right that the pendulum will swing back, and I don't see any private sector demand like there was, and I'm sorry for bringing up things from the past, like there was in 2010 politically on the Hill to rein in the FCPA. I just don't see that ever happening because nobody wants a bill that says, hey, let's engage in bribery and let me support it. On the optimistic note, I also would point out that the Serious Fraud Office did bring a case that, and Scott, you were referring to the one case against the foreign official, but they also brought the first case under Section 7 of the UK Bribery Act for failure to prevent bribery. And it was the tail end of an DOJ case, which is interesting, which was the insurance companies in Ecuador who were getting state contracts, government contracts. So that to me was an absolute shot across the bow, like, okay, you guys may be not doing this, but we're going to do this. I don't think it'll, like what you said, Scott, I don't think it'll ever fill the gap that is there right now. Let me switch to another topic, though, and I want to get your thoughts on this because one of the things that really is important and continuing, and I think that we need to talk about, is corporate transparency and the beneficial ownership legislation, the Corporate Transparency Act. There's been a lot of litigation over it, on, off, regulations and whatnot. Can you guys give us sort of an indication of the importance of that Transparency Act and where you see that going in terms of, along with this sort of parallel track of anti-corruption?
Yeah, Michael, great topic. I mean, to start it from the beginning of this year, the Trump administration took over defending against those 10, 11, 12 federal lawsuits from the Biden administration. And, from reading their briefs, from hearing their arguments in front of these courts and judges, you wouldn't have been able to distinguish the Trump administration's defense of the CTA from how the Biden administration had been defending it. Unfortunately, that all changed the first week of March. As best we can understand, there was an opponent of the CTA who tweeted at Elon Musk in his position running Doge, criticizing the CTA. Elon Musk responded to the tweet, and then 24 hours later, the Department of the Treasury put out a tweet saying it was going to pause enforcement of the law. About 2 weeks later, they then put out what is an immediately effective rule that says that any company that is formed or registered in the United States, so a domestic company, is now going to be exempt from the law. And in practice, that means that, the law that Congress designed, deep, broad, bipartisan law, the law that Congress spent 12 years designing and passing, now 99% of the companies that they had imagined covered under this law are going to be exempt from it. It goes from about 33 million companies to about 12 or 13,000, because the only companies that will be covered is a foreign company that has to register in the United States in order to do business or to buy property. It really depends on state law. But the Treasury Department has gutted the CTA. That became effective on March 21st. They are technically reviewing comments. I encourage anybody who's interested to file a comment. The deadline is in a couple of weeks. But should this policy hold, it is totally an opposite to what Congress wanted here, to what the Trump administration, the first time around, who strongly supported this, wanted. We think it's most likely illegal, too, in that it strays from the text of the CTA so drastically. But it is really setting back a movement that, again, took 12 years to get over the finish line. We know internationally we are going to be found non-compliant with the standards set up by the Financial Action Task Force, the international AML standard setting body. We know that we're going to fail in this recommendation. And, while this becomes the norm for 60, 70, 80 other countries around the world, the United States is now risking taking a huge step backward in in the fight for corporate transparency.
Hey, one question, Josh, before we turn it over to you. You did mention, I think, that Chairman Grassley of the Judiciary Committee, he's taken a public position in support of the CTA, or what? What has he actually done?
So big accolades deserve to go to Senator Grassley's office. He, with Senator Whitehouse, put together a letter that they sent up criticizing this gutting of the law, asking what its basis and justifications were. They were both really instrumental in putting the CTA together originally and in approving it. And so we're really happy to see them say, what are we doing here? This is supposed to be a national security, anti-money laundering, law enforcement tool. And now we're in effect saying, hey, if you want to be able to duck this transparency law, come set up shop in the United States. We're literally providing an incentive for criminals to not form their companies overseas, because if they do that and then they have to register to do business in the US, then they're covered by the law. But if they just simply come to the United States, set up shop here, then they can avoid the law. So it truly boggles the mind that for a law that was so heavily supported and designed around national security, giving our intelligence and law enforcement communities what they need to protect us from terrorism, money laundering, organized crime, anti-human trafficking, you name it, that an administration that has otherwise been so adamant in fighting drug cartels, fentanyl trafficking, and Iran's terrorism would choose to gut this tool that law enforcement and others have been waiting years to be able to.
Josh, your comments on all of this and transparency.
Yeah, no, I mean, the CTA is such a core issue to how we need to approach transparency and corruption and money laundering going forward. I'd like to, if I can, make 3 points here, and I hope I don't ramble too much because this is the centerpiece of really where the fight needs to go. So the first point I really want to make is the administration, if you read the rule, is trying to make a distinction between domestic risks and foreign risks. And they say, well, domestic companies don't need to register under the Corporate Transparency Act because the threat really comes from overseas. But then if, as Scott points out, if you go into the weeds on what that means, it's really only foreign companies that are already registering in the United States and acknowledging their existence and saying where they come from that need to provide beneficial ownership information, which is the last people that need to provide it. Nothing in this law says that Xi Jinping, Vladimir Putin, and the Ayatollah of Iran can't make a joint venture in Delaware tomorrow that is totally anonymous and does not indicate that they are behind the companies. Any foreign actor can set up a U.S. company, and by definition, it is a domestic company and not covered under the CTA, which means that quite literally the red carpet is out for every kleptocrat, drug cartel member, anyone that wants to bring dirty money into the U.S. The shell company, the anonymous shell company, is the path to do that. The second point is they are already doing it in spades. We saw yesterday in the Financial Times, there's a report that Chinese organizations are using shell companies to get around tariffs. You see it in drug cartels using shell companies to set up fake online pharmacies for fentanyl and to launder the money and their proceeds. So this is a crucial national security and law enforcement priority. The final point, and I really want to give kudos to Grassley's office, who's been at the forefront of this, but Grassley's office is very focused on the fact that in the US, you can register a plane with the FAA, and you don't need to give any beneficial ownership about who owns that plane. So if we're worried about terrorists bringing on a box cutter onto an airplane, but we're allowing them to buy planes and not disclose their beneficial ownership, it's a huge national security risk, which is, to bring me back to the optimistic path, why eventually I think this will get rolled back even within this administration. Because if you care, as this administration says it does, about exerting U.S. economic power, if you care about locking down fentanyl and getting it off our streets, if you care about tariffs and stopping tariff evasion, if you care about sanctions and stopping sanctions evasion, you must have beneficial ownership information. What the U.S. government is doing right now is taking off the handcuffs on economic power, and we are very grateful for that. But they're putting on the blindfolds, and sooner or later, they're going to bump into something, and I think, and I hope, that that's when this stuff will roll back.
Yeah, just to add, I mean, the arguments that were made in defanging the Corporate Transparency Act are just totally disconnected from reality. One of them is that this was a heavy burden on businesses who had to report their owners. Keep in mind that a study was done that showed what kind of information was required to start a company in all 50 states, and it was less information than a person gives to get a library card in all 50 states. So under this law, it's name, address, birthday, and your passport or driver's license number. That's it. This is not some deep invasion of privacy by the deep state or big government. If you're Joe's Pizza, it's owned by Joe. And 80% of American companies are sole proprietorships. There's one owner. You know, if you have the resources to create some complex shell company network and you're offshoring, you know, your interests and whatnot, you certainly have the resources to identify who your beneficial owners are. Tens of millions of companies, small businesses included, have already filed their beneficial ownership information. It takes like 15 minutes to do. We probably all know someone who's done it at this point. The idea that this is overly burdensome, and at a time when small businesses are dealing with tariffs and a lack of assistance in other ways when they're really struggling, it really stuns me that you have got so many folks in Congress who are choosing to waste their time trying to roll back the Corporate Transparency Act. There are way bigger issues for the small business community. We hear about them all the time. And to think that getting rid of this law that frankly will help them be competitive, because you're not going to be able to have a scam company compete for a contract or an opportunity with a legitimate company if the scam company now has to report who's actually behind it, right? That's going to out them as fraudsters. This is a way of cleaning up the market, ensuring real merit-based competition. And the idea that you would have groups like the National Federation of Independent Businesses, or S Corp, go around and make this one of their top priorities in this business environment shows a true disconnect from reality.
Well, that, and you both have referred to national security, and what we are about to witness and what the administration has talked about is increasing regulatory, civil, criminal enforcement of trade compliance issues that are close to, and we're also seeing, for example, CFIUS, the process for national security purposes, is going to be ramped up. There are going to be huge compliance implications in trade compliance. And I think you referred to this, Josh, that transparency is absolutely critical. We do with our clients the same kind of due diligence that's needed as to who owns what company for trade purposes, for sanctions compliance, for export controls, and now throw on top of that tariffs and the incentives that people are going to have to circumvent tariffs by creating shell companies that are sitting in Mexico or dealing with a U.S. company as a way to avoid certain tariffs. I think that we could be in a situation where trade compliance could become so costly and so aggressive here that I think your point, Josh, is very well taken, that we may come full circle back to we need transparency. People are paying bribes to avoid detection, for example, on a sanctions issue or whatever. So where is this going to go when you have this national security interest and we're putting all of our eggs in the trade compliance bucket? I will tell you that every company, every client that I know is looking at ramping up their trade compliance programs because of this.
I think that that's an excellent point, and I think that it really is the end of this story. It remains to be seen whether or not the end of the story, again, is this year, next year, or in the next administration. But I would like to first just applaud this administration for elevating economic security and economic power to the place where it belongs as a national security issue. And to do that effectively, you need to use the power of the private sector, which in America is incredibly strong, and you need to go after the cheats that are using non-market practices, IP theft, sanctions evasion, monopolies to harm the global economy. And using tariffs and other trade mechanisms, I think, is a tool that can have tremendous efficacy in bringing people together to a better and cleaner system. However, all of that depends upon transparency. And transparency is sometimes, it has something of a PR problem because transparency is often thought of as a shield. It's the thing where we name and shame and somebody feels bad about themselves. Transparency isn't a shield. Transparency is a sword. Our adversaries depend upon secrecy. They depend upon secrecy to steal our IP. They depend upon secrecy to traffic drugs, to traffic people. They depend upon secrecy to have slavery camps in Xinjiang. They depend on secrecy to have shadow fleets transporting Iranian and Russian oil to China. That secrecy can be attacked with transparency. And eventually, the people who are doing the law enforcement on the economic security tools will understand the importance of being able to see behind that veil. And so again, we advocate strongly that these tools are part of the toolkit of economic power. You have sanctions, you have export controls, you have tariff and trade rules, you have positive power projection, and you have transparency.
I mean, well said, Josh. I mean, I couldn't agree more in terms of there is a sort of rebalancing and recalculation going on. And I think you're right that we should use our economic power for good and to make a sort of level playing field. And that was one of the arguments that was used for anti-corruption enforcement, is that it does actually help to create a more level playing field in that sense. But I want to know, I was going to ask you, Scott, these arguments on transparency that Josh so eloquently outlined, are those resonating with anybody in the Hill? Is that resonating yet with people in the administration? What's your sense of that?
Such a good point and such a good transition to what I wanted to add here. So everybody has heard that within the first, 5-6 weeks of this administration, there was a big pause on foreign assistance, on all of U.S. foreign aid. DOGE disassembled USAID, a lot of the projects and funding that we sent around the world for some really good causes and some, questionable ones were either paused or cut. And at the end of the day, somewhere between 25% to 85% of all of our foreign aid funding ended up being cut entirely at this point. So we've been working with groups like FDD and the Hudson Institute to try and make sure that the foreign aid that the U.S. does spend is done in a smart, efficient way. We think that this comprehensive review has a lot of benefits and was long overdue in some ways. And transparency is such a good example of that. When we often think about, democracy promotion and funding good government programs, it's this touchy-feely. I agree with Josh. It has a PR problem as not being effective, in a harder mechanism for getting American interests to succeed. But think about the value of transparency if we had it tied to foreign aid for countries to figure out whether or not they have allegiance or are influenced by some of our adversaries like China or Iran, if we could use as conditions on that foreign aid ways of fleshing out whether they are working with terrorist organizations, whether they have hidden alliances with drug cartels that could lead to the creation of narco states. Can we use transparency as a means of making sure that our military or intelligence or security hardware services aren't falling into the wrong hands? Can we use these transparency dollars and conditions to make sure that American companies have a wider insight into the markets that they're entering so they can be more competitive, and play on an honest playing field? And then there's always the fact that these are American taxpayer dollars. So can we use these foreign aid dollars to ensure that that money itself is not being stolen by corrupt actors or misappropriated or diverted? Like, that's transparency as a sword. And to your question, we have gotten really great reception on the Hill, including on the leadership level, about baking into the cake for future foreign aid dollars requirements and a framework that when we spend money on transparency or accountability or, good government programs and projects, that they go through this framework of U.S. national interests, of making sure that it's not being stolen or diverted or going to our enemies, or, that these are ways of shedding light in some of the most important and often hostile parts of the world. So I think a really good example of it not only being used as a sword, but there being an audience in important halls of power to be able to start treating it like that.
I love that idea, Scott, of using conditions and demanding transparency. You get our money, but here are the conditions, and here's the way we can use transparency, as Josh said, as a sword. I mean, I guess that's an optimistic moment here in what's been a, difficult time, but I see this in a very positive light, the way Josh described it. I am an eternal optimist. I know it's tough, probably day-to-day at Transparency International, to find those moments, but you is what I'm hearing from you. And I sort of want to close out, because it's been a great discussion, but I want to close out sort of each of you to give you a few moments to talk about, the optimist course here in terms of where you see this ultimately playing out. You have some really significant forces here at play. And I'd love to hear from each of you to close it out here on where you see this going, because I think American businesses and global businesses need to look at it in this light, the light that you're talking about.
Yeah, I'll say a lot of credit on this thinking also goes back to the good folks who put together the National Security Council's U.S. strategy on countering corruption, because they saw this issue of transparency, good government, and democracy writ large as a sword, as a means of having America and its allies succeed over our adversaries. And so what gives me hope is that you have this real, strong, building community of people who want the United States to succeed in a moment of competition that we haven't seen, certainly in my lifetime, but since, the fall of the Berlin Wall or the end of the Cold War, or maybe even all the way back to World War II, that the United States' hegemony is already being challenged by forces that are maintained and put into power and financed by corruption. Xi Jinping and his network are only in office and only able to maintain their power by stealing from their own people. The same goes for Russia, Iran, Venezuela, etc. And so us understanding that the principles of democracy, of open and accountable government, is a way for us to band together with our allies and to overcome the threats posed by our adversaries. That's what gives me hope. That's a boat we can all ride out on. That is a set of ideals that I think can bring together a really strong and durable constituency for both American interests and broader global interests.
Well stated, Scott. Josh, we'd love to hear your optimistic end here.
Fantastic. Well, I always say that I am an optimist of the possible and a pessimist of the probable. But in this case, I think there is a path forward here that we could all be somewhat cautiously optimistic about it. And it's this. This administration, for all of the issues one might criticize it for, is open to a reorganization that we haven't seen in decades. And to Scott's point, there's a lot of things that did need updating, that did need change. The reorganization of the State Department, still very much a process that's ongoing. The openness to think new ways does give a pathway for those of us that care about national security, to care about transparency and see the intersection of those, to make our case. And I think ultimately our case is strong, that we are stronger as Americans when we play on a level playing field, that our private sector thrives when things are fair and free, and that America will defeat its adversaries if we play by open and transparent rules. And if that's the goal, and I think it is at this administration, I think we have a story to tell, and we must be telling, that will eventually resonate. And the arc of history is long. I don't know which way justice bends, but I know that we have the better case here, and I think ultimately it will prevail.
Well said, both of you. Thank you so much. This has been terrific. I will probably impose upon you later in the year to update us on what has happened and what you see going forward. These episodes, I will tell you, end up being probably our most listened to episode, when people can, and I think it'll be even more important in the current environment, because businesses are struggling a little bit on what's the way forward. And I think you've given them a path and given them a really good prediction, I think, as to where we're going to go. Now, in case anybody, and I hate to put you on the spot, but in case anybody wants to, any of our listeners want to reach you, Scott and Josh, can you each give contact info or the best way to get in touch with you so that people can ask you follow-up questions or ask for some help?
Yeah, you got it. I'm at Greytak, Sgreytak at transparency.org, and you can find us on X at Transparency USA.
I am at J Birenbaum, JBIREN as in Nancy, BAUM as in Mary at FDD.org. And I welcome any comments or thoughts.
Well, thank you both again. This has been terrific, and we'll have you back. And we look forward to hearing what your perspective is down the road. Thank you again. Thanks, everybody, for listening.
If you enjoyed this episode, the best way to support the show is by subscribing on your favorite listening platform. To learn more and connect with Michael Volkov, go to volkovlaw.com.